So, one immigration question I'm constantly getting, and of course I don't know the answer to, is hey, I just married a U.S. citizen, so now what do I do?
Well, the answer kind of depends on how you got here to the United States. It's very different whether you came across the border with a visa, or you waved through inspections, or whether you came across the border, without authorization and through the desert on foot. There's kind of two general ways that we handle these cases, and of course, there's always exceptions, and you should always talk with an attorney before filing any paperwork with immigration to make sure you're eligible. But in general, what we're looking at is you came across the border and you were inspected, admitted, or paroled. We do an adjustment of status application for you, which is a one-stop shop. We file the I-130 petition that's filed by your U.S. citizen wife. We do an adjustment of status application that's filed by you. And after all that stuff is adjudicated by CIS, you should get your green card, assuming all goes well. Of course, there's always exceptions to that. The other way of doing it is now the regulations have changed and allow us to do a provisional waiver. The biggest problem we have in cases of people who come across the border without a visa or without being inspected, admitted, or paroled is that they are having to consular process, which means they have to go back to their home country to be able to get their green card. The problem is once you've been in the U.S. for longer than 180 days, and then you leave the United States, you trigger what we call the unlawful presence bar. In general, this means that you're unable to come back to the United States for 10 years unless you're eligible for a waiver. We call this the 601 waiver. And we're now able to file that waiver here in the United States. So what the process looks like, if everything is smooth and there's no criminal record or fraud or anything else we need to worry about, is we do the I-130 petition, which is filed by your U.S. citizen spouse. Once that's approved, you pay all your National Visa Center fees, your affidavit of support fees, and then we go ahead and file your 601A waiver, assuming that we're able to meet that standard of proving that your U.S. citizen spouse or LPR spouse will suffer extreme hardship if you have to leave the country. Of course, this is a determination that is usually made in a consultation where we can talk about what hardship may occur to your spouse or your parent, who's also a qualifying relative, and then we can help you decide from there if this is something that you are eligible to apply for.